Kia ora and welcome to Goodfellow podcasts. This episode is kindly supported by the Royal New Zealand College of General Practitioners, the Auckland faculty. The content of this podcast was developed independently and the views expressed are those of our expert speaker. Today we're discussing enduring power of attorney, a critical legal aspect that every primary care provider should understand. We're joined by Dr. Helen Kenealy. Helen is a geriatrician and general physician and has worked at Counties Manukau Health, Te Whatu Ora and Green Lane Medical Specialists, but is transitioning to an exciting non-clinical position as General Manager, Clinical and Risk, MetLife Care New Zealand. She has completed the Monash short course in perioperative medicine. Helen sees a wide range of conditions and performs home visits, and has experience in capacity assessments and legal reports for both clients and the court. Kia ora, Helen, and welcome back to the podcast.
Nice to talk to you again, Louise.
So let's start with the basics. What exactly is an enduring power of attorney and how does it differ from a general power of attorney?
That's a really good question, but let's just start with a disclaimer that I'm not a lawyer, and anyone who wants to set up an enduring power of attorney or any doctor that's assessing a patient and feels that they need some advice for either them or their patient should always get their own independent legal advice. An enduring power of attorney in New Zealand is a legal document. So it legalises a decision that a competent adult makes as to who could make decisions on my behalf if I lose capacity to make my own decision or communicate my own decision in the future. When I say communicate, bear in mind that as doctors we know that, for example, some patients who have a stroke could develop a significant aphasia, and then we wouldn't be able to understand what their decision-making ability is. On that note, we must always maximise a person's ability to communicate. So you have to make sure the patient has their hearing aids, offer them a hearing amplifier, ensure they have their glasses, use an interpreter as needed, and offer them a pen and paper. I have let patients over the years where we were unable to communicate in spoken form, but once given a pen and paper, they were able to show us that they had capacity. Enduring powers of attorney operate under the Triple P&R Act, originally written in 1998, and that stands for Protection of Personal and Property Rights. EPOAs are covered in Part 9 of that Act, and although it may seem tedious, if you ever do get the chance, it is really good to actually read the Act and get a sense yourself of some of the terminology and the important aspects of it. So going back to your original question, to make clear, there is a separate thing called power of attorney. So there's no E, it's not enduring. And that isn't a legal document that is legislated in this country. It's a specific agreement, for example, with a specific bank. So say my mother is perfectly competent, but is really struggling because of hand arthritis to manage online banking and apps and making payments. So she might take me down to the bank and say, please, can my daughter have power of attorney for my accounts that she can provide oversight and assistance for me with my financial matters. So that's just a very specific arrangement that ensures that liability between the individuals and the bank is made clear.
So I wonder if we can pick up on some of the terminology used in enduring power of attorneys, please, Helen, starting with donor.
Yes, because a lot of these terms are a bit confusing for us doctors. Donor, in this sense, we can think of as patient. So the patient or the person who grants to another person the enduring power of attorney.
And then attorney, what does this mean?
So attorney is the person that you give the power to. So the holder of the power of attorney granted by the patient.
What about capacity to make decisions?
So the Act is very specific around a number of these issues, and capacity is defined by the Act. There's a couple of points to note. One, terms like capacity and competency are interchangeable. And the second important point is that the Act specifies every person in this country is presumed to have capacity until the contrary is proven. And that's really important because a person must not be presumed to lack capacity or competence. Just because the person is managing or intends to manage a situation in a manner that another person, such as ourselves, might think it is not prudent or not the way that we would do it, not the decision that we would make. In colloquial terms, you could say that the Act allows for the fact that people can make dumb decisions while fully competent. So we, therefore, as health professionals, when we're assessing capacity, need to be very careful that we are not judging the decision the person is making. We are simply judging the process through which they are making that decision. Now, the Act does specify that there are 4 components to capacity. So a person lacks capacity if they fail to make a decision, if they cannot understand the nature of the decision, if they fail to foresee the consequences of the decision, or any failure to make such decisions, or, as we alluded to before, they lack the capacity to communicate the decision.
Helen, the term used is health practitioner rather than medical practitioner. So who is a competent health practitioner in this setting?
It's very good to clarify that point, because this is one area under which the Act has had amendments and changes made to it over the years. So health practitioner has the meaning given to it by the Health Practitioners Competence Assurance Act, which came in 2003, so that postdated the original PPP&R Act. And that meaning is given in Section 5, parenthesis 1, parenthesis. So that is more encompassing than just doctors, and indeed more encompassing than just doctors and nurses. So the Act currently states that to assess capacity, you have to be an appropriately qualified health practitioner. The way I think it's easiest to understand this is that, first of all, it doesn't have to be a doctor, but if you're not a doctor, you do have to be appropriately qualified. So at Counties Manukau, we have an excellent team of community geriatrics nurses. They're clinical nurse specialists. They can assess capacity. They have had adequate, indeed extensive training and extensive experience. So they would fall, for example, under that as an appropriately qualified health practitioner. And I think as GPs and myself as a generalist know, anytime we see a patient for any reason, we have to assess our own knowledge. Do we have the knowledge to assess and treat this patient? And that is the same for capacity. Do I have the training and knowledge to assess this particular patient's capacity in this particular situation? And there will be some as a GP where you decide you do, and there will be some where you decide you don't, and then you must refer on or seek advice.
Thank you for clarifying that. So there are some other terms, jointly and severally. So what does this mean?
So they're legal terms, yes. So a little bit confusing for the rest of us. Just to be clear, these terms don't apply for personal care and welfare EPOAs, because you can only appoint one person or one attorney at a time. You can specify that your attorney has to consult with other people, and you can appoint, and indeed I think you should appoint, successors, so that if the person who you put down as your preference isn't available or willing to take on the role at the time, you do have some backups. So these terms only apply to property, which is the EPOA that you can appoint more than one person or attorney to the role. So, for example, you might appoint 2 of your children. So as it's written, you then have to decide, can they act by themselves, which is the term severely, or do they have to act jointly together for every single decision? So this is, quite nuanced, and really individual patients or donors need to discuss these decisions with their lawyer around their specific individual circumstances and the pros and cons of those decisions, to make sure that they understand the practicalities of those decisions and make the best decision for their circumstance.
So Helen, you've mentioned that there are 2 types of EPAs. So I wonder if we can just talk about those a little bit more now. So there's property and personal care and welfare. So can we start with property EPAs? What does this mean, and what's covered here?
Sure. So when you hear the term property, you think of your house, but it's much more overreaching than that. Property means anything that you own. So your physical possessions, so of course house, business buildings, any assets like a car or a boat, but it also includes your money. So it does grant the attorney access to your finances. So the best way to understand it is that if I am the attorney for my mother from a legal perspective, I am my mother when it comes to making property and financial decisions if the EPOA has been activated. So I can sell her car or her house. But the law is clear that I can only do so for the medical and health benefit of the donor. So a practical issue would be, for example, mum needs to go into care. We need to pay for the care. We therefore need to sell mum's house to release that cash to pay for her care. So in that circumstances, I would be justified in selling her property, her asset, because it is for her medical and health benefit.
So what decisions can the personal care and welfare EPA make?
Yeah, so an attorney must always promote and protect the welfare and the best interests of the donor. The Act also says that they must encourage the donor to be as actively involved as possible in decisions, and that the attorney is responsible to seek to facilitate the integration of the donor into the community to the greatest extent possible. So this is quite an important point, because when you're the activated EPOA, for example, for personal care and welfare, you can't just go and see the GP without the patient and start making a whole lot of decisions without any consultation with that patient. The law is designed that the patient is still involved to the best of their ability. Ultimately, the decision does lie with the attorney, that's true, but that the patient shouldn't be completely excluded from any decision-making process. And the donor must always consider the financial implications. So if I wanted to keep my mum at home and not put her into care, and I calculated that was going to cost $3,500 to $4,000 a week, well, I still need to figure out where that money's coming from. So your care and your welfare are not separate in that sense from financial decisions. So they do need to be made in conjunction with each other. There's some interesting things in the Act around what the attorney can't do. So an attorney can't marry off the donor or dissolve a marriage or a civil union. They can't adopt or have anything to do with adoption of any children of the donor. The most relevant one for us as health practitioners is that an attorney can't actually refuse consent to the administering of any standard medical treatment or a procedure that's intended to save that person's life or to prevent serious damage to that person's health. So there are limits in that sense around what the attorney could refuse. We also have to be aware that there are other acts that sit alongside the Triple PNR Act. So, for example, the Triple PNR Act specifies that an attorney cannot consent to the administration of ECT therapy. That doesn't mean the patient can't get it. It's just that that sits specifically under the Mental Health Act. That's not a role for the attorney for personal care and welfare to get involved in. There's also limitations around consent to brain surgery, particularly if it may alter the person's personality or behaviour. And an attorney can't consent to medical or medication experiments other than if it was being conducted for the purpose of saving that person's life or to prevent serious damage to the person's health. So there is a little bit of flexibility there if needed. And there has been an amendment to the Act to say that no attorney can utilise the option of assisted dying under the End of Life Choices Act. So at a practical level, the most common issues that we see would be that a personal care and welfare attorney might sign consent, for example, for a procedure where a patient's deemed incapable of making a decision. For example, they've fallen, broken their hip, floridly delirious. So at that point, we would activate an enduring power of attorney for personal care and welfare to allow the attorney to consent for that procedure. And the other most common one that we see is about where a patient's going to live. So in a situation where a patient is living at home, but there are grave concerns for their safety, health and well-being in that setting, and that there's a feeling that perhaps they would be better in residential care. However, going back to points we made earlier, we are there only to judge the process by which they're making that decision. We're not there to judge their decision. I've certainly met multiple competent people over the years who have been adamant that no matter what, they are not leaving their home, they are staying there, they're not moving into care. And if they can talk through, those 4 basic tenets of capacity with you, that they understand the nature of that decision, they understand the consequences that can be quite negative. They're staying home alone when they're frequently falling, unable to provide their own nutrition adequately and so on. You may still deem that they are competent to make that decision, even though others disagree with that decision. So you do need to be careful in that situation.
That's a really tricky one. So practically, how do you set up an enduring power of attorney?
So they're legal documents. So you do have to go and see a lawyer. And you could go and see your local family lawyer, someone that you've seen before. The legal profession is much better, I think, now at prompting people. For example, if you're buying and selling a house, that would be a good time for your lawyer to say, hey, are your wills up to date? Do you have enduring powers of attorney? If not, you're already in contact with the lawyer. It's a great time to set them up. There are entities such as Perpetual Guardian or Public Trust where you can go and they are able to provide those services as well. There are multiple options now to be able to do these things online, and some companies have set fees, so it's a bit more transparent. But the upshot is that it is costly. So once you've got your advice and you've written up your enduring power of attorney, you do need to physically see the lawyer. Sometimes they can do these things over scanning an email, but for argument's sake, let's say you go in to see the lawyer and you sign it with a witness present, yeah? And remember that the attorney also has to be given legal advice. So they have to be told, your mum wants you to be her enduring power of attorney of personal care and welfare. This is what it means. It's not active yet. Here are your rights and responsibilities. Are you willing to take on this task if or when needed? And then you would sign with a witness present. So it can be costly. There are some instances where people may be able to access it at a low cost level. For example, community legal services in Otara have a very low, very reasonable fee open to locals who are beneficiaries. So there are options out there, but it does cost money to set them up.
Helen, as medical professionals, we often find ourselves at the intersection of medical and legal decisions. So when should a primary care practitioner be aware that an enduring power of attorney needs activation? And can you shed light onto the triggers or situations that prompt the activation of an enduring power of attorney, especially from a medical perspective?
Sure. So the Act is very clear that there has to be a trigger or a reason to do a capacity assessment to then look to activation enduring power of attorney. And actually the activations are trigger specific. So if we think back to the lady who had a broken hip or a fractured knob, she was so delirious pre-op that we activated her enduring power of attorney, and her daughter sought information and signed the informed consent form for mum to have that fractured knob repaired. That activation does not actually last now into perpetuity, right? That activation was only for that specific event. Mum may well recover from her delirium and then be able to re-enter into making decisions about her personal care and welfare. So we do just need to be a bit careful around those subtleties, because that can get people a bit confused. As health professionals, we can't just activate an EPOA for personal care and welfare just because we think in general that a patient can't quite understand their medical conditions in a sort of general sense. You have to cite a specific issue. I have been asked to assess the patient's capacity for deciding X, whether or not to have their fractured hip fixed, whether or not to undergo complicated chemotherapy. And you have to assess for that specific decision. So you can understand that it's usually activated for major treatment or surgical issues. Or the other most common one would be decisions around moving into residential care. So decisions about where it's most safe for a patient to reside.
Communication is key in healthcare. So how can we effectively communicate the importance of having a power of attorney to our patients?
Yeah, I think as health professionals in the aged health workforce, we certainly all feel that there does need to be more general education of the public. As not a lot of people are really up to date and understand this. And I also think there is some onus on the legal profession, as I say, that when they have contact with people, for example, buying and selling houses, that's a really good time to bring up these issues and encourage people to establish wills and enduring power of attorneys at that point. There's a lot of resources that you can refer people to as a GP. So there's the consumer website, public trust website's really good, as is the Ministry of Justice website. We should really be encouraging all patients to have them, even at our age, and I already do. And another really good resource is the Office for Seniors website. I think if GPs can think of this discussion like a brief intervention that you do for smoking or alcohol, it's pretty similar to try and encourage people to get this legal paperwork done.
So strategies or tips to initiate these conversations, because they can sometimes be a bit tricky with patients. So any tips there?
Yeah, they can be tricky. I've really developed that I ask every patient as part of their social history, do you have a will? Do you have an enduring power of attorney? If they don't, then I provide brief education and direct them to resources and encourage them and put it in the letter. I've advised the patient to seek legal advice about establishing enduring power of attorney in a will. And if they aren't sure, I encourage them to check, because obviously that's a great time to prompt them just to get everything in order.
So documentation is also really important in healthcare. So how do we ensure that we appropriately document and record interactions involving enduring power of attorney? And can you provide any guidance on the necessary documentation or record keeping that we should follow when dealing with patients who have had their enduring power of attorney activated?
Sure. I think the biggest and most important issue here is very simply, if you don't have a copy of the enduring power of attorney, it doesn't exist. So people will tell you all the time that they have one or they think they have one, but unless they can actually produce it, it just doesn't exist, and you can't act on it as a health professional unless you've personally seen it. Over the years, I've seen people think they have one and actually they have a will, but not enduring powers of attorney. They have the power of attorney with a bank, which doesn't obviously provide the legal framework that I need, or they got them drafted but never signed them. So there could be a lot of reasons why people actually think they have one, but they don't. If people want you to act on an enduring power of attorney, they have to provide you a copy for it. So you should not even begin a capacity assessment without having a copy of that enduring power of attorney. That is actually an infringement on a patient's rights. You have to be able to say to a patient what you're doing and why. I have a copy of your power of attorney. I'm assessing your capacity for the following decision. That is a basic human right, that people are provided with that information and that certainty. And if a patient says, I'm the activated attorney and I'm making decisions about mum, they are not until they provide both a copy of the power of attorney and the activation certificate. If they don't exist, it isn't there and it isn't activated. So that can sort of lead you into a bit of conflict with people, but that is not negotiable. As with any documentation that we make in medicine, it needs to be as thorough as possible. But in many ways, you really want to perhaps up your game or ensure that your documentation is exemplary, because anything dealing with capacity, enduring powers of attorney, wills, any of that can and indeed may well be reviewed by lawyers and courts if it came to that. So you really do want to make sure things are as thorough as possible. You cannot assess a patient's capacity without seeing them, without having a clear trigger, and without taking sufficient time. So I feel strongly that there is no way that a GP can assess capacity in one 10 to 15 minute appointment. I think even in the context we have known someone a long time, I still think that would be very difficult to formally assess capacity in that time frame. And I think therefore any decisions that you made through that short assessment could be challenged. So yes, it does mean that patients need to book double or longer appointments. It does mean that we need to get better at being upfront about that with the patients and upfront about the cost of it, because it will increase the cost for people, which I know is a huge issue for some people. As we said before, at any stage, as a GP, you feel that this patient's assessment of capacity in this situation does not feel right, something that you are not able to assess, then you should seek advice, discuss with public or private colleagues as the case may be, and seek formal second opinions where necessary.
So I wonder if we can just touch on assessing capacity. So it is a complex task that takes time. So what do we need to know as far as assessing this?
Yeah, it is a complex task and it may take time. As I said, I don't think it can be done in 10 to 15 minutes. And indeed, even for us as geriatricians, often, of course, we are seeing quite complex ones. We might need to see patients 2 or 3 times because consistency is also part of capacity. So I don't think that we should be rushed into making a decision around capacity if that's not appropriate. There are multiple issues to consider when activating the EPOA. You need to review it. You need to ensure that you are happy, it's signed, it's been witnessed. You must clearly document what the trigger is. You do need to understand the social and financial situation of the patient. So I often start with asking them to tell me, who's in your family. You're assessing capacity as well as getting an idea about their social backgrounds, because obviously if they can't tell you how many children they have and what their names and ages are, you're already starting to build up a picture that this patient perhaps has significant gaps in their cognitive and memory function. You may well need collateral from family, friends, lawyers to know whether the information you are being provided with is correct. If you're assessing for a property EPOA, you need to know what the house is, how much is it worth, have they sought any sort of valuation either formally or from agents as to the value of it? Do they have a mortgage on it? What sort of income are they getting in? Is it the pension? What other income do they have coming in? These are the sorts of questions you need to ask to sort of be understanding whether someone has capacity to make decisions around their finances. Do they have any other money in term deposits or otherwise? And of course, you don't know the veracity of that information, which is why you often need to seek some external collateral to confirm that or not. You need to follow the ideals as per the law. So you need to maximise the patient's ability to communicate, which you've already covered. You need to have discussions with them about whether they can manipulate and understand the information. Can they tell you what the current council CV of their house is? Do they understand that real estate agents may think that that value is different from the CV? They don't have to be able to tell you, oh, well, the market's up or the market's down or this or that. They just have to be able to say, well, the council thinks my house is worth $1 million. I've had some agent through, or I'm going to get an agent through to get a valuation, and I might get 2 or 3 agents through so that I can get an idea of where agents think it sits in the market. And so if the agents come through and they say it's worth 1.2 million, okay, well, currently people are thinking it's a bit above CV, so I don't really want to let it go for too much under CV, or some sort of sensible discussion like that you can see that they can understand the information and manipulate it. We all know that, buying and selling houses is extremely complex, and obviously, your house is only worth what someone's willing to pay for it. But that's part of the process, is trying to understand where those figures might land. Can they understand the consequences of their decision or not making a decision? So what's going to happen if you sell the house? What's going to happen if you don't sell the house? Are they consistent in their wishes? That consistency argument. People can change their mind when they just explain why they've changed it. So initially, I really wanted to give my enduring power of attorney of property to my second daughter because, she's a lawyer and a trained accountant. And she'd just be awesome at understanding the legal and financial aspects. But she's just decided to move to Dubai. And look, the lawyer says that you can do things electronically nowadays, but I just think that's too complicated. So I've decided that I'm going to give the enduring power of attorney of property to my oldest child, who, okay, isn't an accountant, but you don't need to be to do this work. And they're very sensible, and I think that they'll do a good job, right? So you're allowed to change your mind. You just explain the reasons. So the common one we'd see is a patient who clearly wants to go home and there are safety concerns, and that's really complicated, and that's hard to cover off even, in an hour for a geriatrician. I've certainly had fully competent patients tell me that they would rather stay at home, and they've been able to say to me, I understand that I might fall over. I understand if I fall over, I might break my hip or my back. I understand then that I may lie on the floor for 24 hours in pain and wet my pants because I can't get to the toilet. I can't get to a phone to make a phone call. If I've been silly enough to leave my medical alarm on the kitchen bench and I don't have it on me, I understand that I then could die on the floor. And that, to me, dying at home is more acceptable than going into care. If someone can be so clear with you that they understand all of that, they understand all of those consequences, then there's a classic example of where it's not up to us to judge the decision. We are there to judge the decision-making process, and therefore we must respect their decision. So that's not a lack of capacity, that's just a different decision than what perhaps the assessor might make.
You mentioned changing enduring power of attorney. So I wonder if we can just touch on that for a minute, and also when enduring power of attorney ends.
Yeah, so that's a really complicated issue, and probably you need to have legal advice on the specific situations. If you're a competent person, you can change, revoke, do whatever you want with your EPOA. Okay, that's not a problem. It is difficult once the patient's lost capacity and they have an activated enduring power of attorney. Then you really need legal advice, and you need to go to seek application to the court, the family court, to have a look at it. So it can be tricky. I mean, an EPOA ends when someone dies.
Yeah.
Or if I said before, actually what is poorly understood is that if I activate an enduring power of attorney for a specific instance, that instance resolves, actually the activation lifts at that point. So the enduring power of attorney is still present, but it's not activated at that point. So it kind of depends on where patients are at with their competency at the time they want to make decisions. And it also depends on what the circumstances are. For example, if you're a sibling and you're worried that you have a sibling who is enduring power of attorney for property but is misusing funds, you can make an application to the court and say, I'm concerned that this person is not acting in the best interests of my mother's personal care and welfare with their financial decision making. Difficult thing to do, of course, for many reasons, but it can be done, and there is a process to follow, but it requires legal advice.
And what steps can we as healthcare professionals take to ensure that we're aware of any updates or revisions made to a patient's enduring power of attorney? And how frequently should we inquire about this?
So that's a really difficult question, because there's no register in this country for wills or enduring powers of attorney. So people can say, I've got one, but if they wrote it 15 years ago, they can't find a copy of it and they can't remember the name of the legal firm that they did it. Therefore, they don't have it anymore because they can't produce it. So you're very reliant on the patient and the family, either providing the enduring power of attorney for you or giving you the details of the lawyer that you seek it yourself. In some instances, that's the easiest way to do it. As health professionals, it's accepted that we can only act on the paperwork that's in front of us, and that to the best of our knowledge, that is the most up-to-date, current and accurate EPOA. So you would act on what you're provided with unless there's reason to doubt it. Pretty tricky if you're presented with 2 EPOAs, which has happened. Legally speaking, you're going to use the latest one unless there was concern around the capacity at the time that the person signed that. Those sorts of situations are tricky, and you would seek legal advice as a health practitioner about it. So I think you should try and ask people, it's not realistic to ask them every time you see them, but probably at least once a year. Have you got a will and EPOA? Oh, yes, I've told you that before, doctor. Oh, awesome. Have you changed them or made any revisions to them since we last saw you?
Wonderful. Well, thank you for that, Helen. As we wrap up today's episode, your 5 essential take-home messages that you'd like to leave with our audience.
So if you have the time, I think read the Triple P&R Act online and familiarise yourself with it, particularly Section 9, which covers enduring powers of attorney. It's not long to read, but it does give you a really good sense of the legal framework that you're working under. I'll remind you all again that there must be a trigger to assess capacity, and that must be documented. Capacity assessments are complicated, and I really think that anyone would struggle to do an assessment adequately in a 10 to 15-minute appointment. So I encourage GPs to continue to educate people that longer appointments are needed. The Act actually states out what information must be included in an activation certificate. Te Whatu Ora has put out standard forms, and always seek advice from geriatricians, psychogeriatricians, and lawyers as needed to guide you in this tricky area.
Great. Thank you so much, Helen, for sharing your expertise on this topic. To our listeners, we hope this episode has provided valuable insights into enduring power of attorney in the context of general practice. You'll find a list of resources on our website, goodfellowunit.org. And if you're a New Zealand GP and would like to claim points for listening to this podcast, our podcasts are eligible, so please log them.